Number 40, 41, and 42, matter of Acevedo, Carney, and Matsen against the New York State Department of Motor Vehicles. Counsel?
Good afternoon. My name's Eric Sills. I represent the three named petitioners, appellants in these cases. I also currently represent over 350 additional similarly situated individuals. I'd like to, if I could, reserve 2 minutes for a rebuttal, please.
You may, sir.
In 2006, the legislature enacted a recidivist DWI offender policy. In 2012, DMV decided that the policy wasn't tough enough, and they overruled it. Every single provision...
But how is that in conflict with the authority that the commissioner has, simply because the legislature chooses to speak specifically about one matter? How does that foreclose the commissioner from exercising very broad discretion?
Because no matter how broad the commissioner's discretion is, it has to have limits, and it can't be unfettered and unbridled. And because some of the statutes cited by respondents would appear to give the commissioner unlimited discretion, you have to search through the VTL to find some limit somewhere. And I believe that Vehicle and Traffic Law Section 1193 2B12 defines the upper limit of that discretion. Now, it's well settled that if there's a statute and there's a regulation and they are in direct conflict with each other, the statute...
But that's what I'm not clear about your argument. Where's the conflict?
Where's the conflict? There are multiple conflicts between, I'll call it the statute, and what I'm referring to 1193 2B12, and I'll call it the statute to avoid repetition.
Mm-hmm.
Under the statute, a person doesn't qualify for permanent revocation unless they have either 4 DWI-related convictions within 4 years or 5 within 8 years. And even if they do qualify, it would be an 8-year permanent revocation. Under the regulations, 5 within your entire lifetime means you're permanently revoked. So if it's really just 5 in your whole lifetime for the regulations, then a statute that says you need 5 within 8 years has been rendered ineffective.
But Counsel, doesn't the commissioner always retain discretion to decide to waive that lifetime revocation?
I'm glad you asked that question, Your Honor. I have been persistently arguing for 4.5 years now that this waiver provision is nothing short of a farce. We have not been granted a fact-finding hearing on this, so we have to rely on anecdotal evidence. But even in this record, we know that according to DMV, 4 waivers have been granted out of over 1,000 waiver applications. And realistically, I can assure you that the only reason 1,000 people have even tried for the waiver is because everybody knows it's just a complete waste of time, and so they're not even attempting to get the waiver. Now, if you look at the waiver provision itself, which is Regulation 136.5 Subdivision D, even in that regulation, it says that the commissioner can deviate from the general policy. So the waiver regulation actually uses the word policy. I think it's clear here that this is policy making.
Counsel, could the commissioner, just in in Acevedo's individual case, have done what you're calling a policy permits her to do? Could you have just done it in this case, on the facts?
Which of the 3?
Acevedo.
Acevedo. Mr. Acevedo had his 3 DWI-related convictions within 5 years, I believe. So he didn't qualify for permanent revocation under the statute, which would require 3 within 4 years. If he did qualify for the 5-year revocation, the statute appears to mandate a mandatory waiver after 5 years because he only has those...
Doesn't it allow the commissioner to decide otherwise? That's a yes or no.
I'm not sure I can answer it yes or no, and I can explain. There is a public safety and welfare exception, but because Mr. Acevedo has no other driving-related convictions in his entire life. It would seem that any...
But again, doesn't that fall within the commissioner's discretion that's provided for in the statute? Is that not?
No,
Correct?
because the statute has a default to a mandatory waiver subject to a case-by-case.
And that's what I'm asking you. Could not the commissioner, looking at this individual case, have decided that the license is suspended and not going to be reinstated?
I would submit that if a person has only 3 DWI-related convictions ever, and they fall under every other waiver provision, it would be an abuse of discretion to say that on a case-by-case basis, this person didn't qualify for reinstatement, because it would mean no one will ever qualify for reinstatement.
Counsel, there's a little bit of confusion to me in this statute in 1193, because there is this provision for a case-by-case exercise of discretion. And then there are 2 later, arguably much broader grants of discretion in relicensing applications given to the commissioner. So how do they square up? So if you look at one, for example, is notwithstanding the provisions of this clause, nothing contained in this clause shall be deemed to require the commissioner to restore a license to an applicant, and then reissuance of license restrictions, except as provided in this paragraph where a license is revoked. No new license shall be issued after the expiration of the minimum period specified in such paragraph, except in the discretion of the commissioner.
Well, I believe in this court's Swalback versus State Liquor Authority case, they dealt with a similar situation with that, which is you can't have a general policy and then just say because you could have used a case-by-case discretion,
That's
you
really
never
not my
do.
question, though. It really is, if you've got 3 instances of the legislature making very clear that the commissioner of DMV retains this broad discretion, I think you have a difficult argument that anything that they have done in terms of using the provisions in here as a floor and putting stricter scrutiny on relicensing applications conflicts with this statute.
If the language that says the permanent revocation shall be waived after 5 years as long as the conditions are met means that you can use the default provision and say what we mean by shall be waived is never waived ever, then I think it's misreading the waiver. The waiver is a case-by-case.
Are you saying it means must, then? It must be waived?
I'm saying that I'm sure there are individuals where you could say this particular person cries out for not getting a waiver.
Well, that's not must. Must be waived means that...
No, that's what I'm saying, what the case-by-case review would be. That there
So
has-
you're saying that
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 it's a-
shall, let me just finish.
Sure.
You're saying that shall, answer my question.
Sure.
That shall doesn't mean must. Are you saying it means must or it doesn't?
I'm saying it provides a general rule of must, but every rule has to have an exception.
I see.
And have a safety
So you're
valve
saying
in it.
there's still room for discretion there?
On a true case-by-case basis.
I get your argument, respectfully. I wanted to take a step back and ask you about the underlying philosophy, because it seems what you're arguing to us is that the legislature appeared to intend that it must be waived, which in my mind means shall. Shall means must. So the DMV, in essence, would be granting licenses to the most dangerous drivers. But in all other circumstances, the DMV would then retain almost complete discretion. And I don't see how that could be what the legislature intended. Because your reading of the statute is that. Your reading of the statute is, really, they must do this. Must means must, and there's no discretion here. Now you're telling me something a little bit different. But in essence, these are the most dangerous drivers on the road, yet that policy doesn't apply to everybody else. It doesn't make sense to me.
I have 2 responses.
Go ahead.
The first would be that this court has repeatedly made clear there have to be some guidelines, principles, rules that limit discretion. And if what I'm getting the sense here is that you're saying they've been delegated unlimited discretion, and there doesn't have to be a single limit on it.
It's always a mistake to try and anticipate what we're thinking. I can't do it.
But,
So don't bother, don't try.
okay, I apologize for that.
Sorry.
But there has to be some limit on the discretion. I've been trying to find limits on the discretion. The respondents have, to this day, not provided a single limit on the discretion. So So that, that's been an issue.
So then would the point be that the other provisions are invalid if they were ever to come into play because they give unlimited discretion? Because there is unlimited discretion on relicensing.
In Boreale, the court said that even under the broadest delegation of discretion, the court, in effect, has to go fishing through and
That's a
find-
different analysis they were talking about there. That's a separation of powers analysis. So just on a conflict analysis.
Yes.
Or a preemption, whatever you want to call it, to get back, which is where I am stuck, where Judge Fahey is, you seem to be saying that with respect to what the vehicle and traffic law identifies as the worst offenders, for relicensing, the discretion is cabined on a case-by-case basis, and it's not. For anything else where you have your license revoked, which would be much less in terms of what this contemplates, you have unlimited discretion, DMV.
Well, my response would be that if you look at the statute progressively, and the VTL has been repeatedly amended and updated over the years, the reason that VTL Section 1193 2B12 was enacted was because the legislature thought DMV was giving licenses back too soon, okay, for these recidivists. And so they said, they shouldn't be getting at 3 offenses their license back in 18 months, which was the policy, and 24 months for 4 within 10 years. And as a result, what they did was create what they thought was a very, very tough
Or a
statute.
floor. Or a floor, that they thought they weren't being tough enough, so it's almost like a mandatory minimum.
But then they wouldn't have said shall be waived after 5 years, and they wouldn't have said after 3 years, DMV can give out conditional licenses. And I know my time's up, but...
But then why are they saying that the commissioner may, on a case-by-case basis, refuse to restore?
Because on a case-by-case basis...
Isn't that again recognizing the commissioner's discretion?
It's the discretion that even amongst these people, there have to be some who should be singled out for individualized treatment, but not as a group of thousands of them. And a point I would like to make is, what are these
But
people...
isn't the broad discretion of the commissioner to also decide the best way to implement this authority? And that if the commissioner's already decided a certain type of repeat action within a period of time, would always justify the suspension and need not say that repeatedly in every single case. You can decide that at the beginning and issue that kind of directive to everyone.
But that would be making value judgments, that would be setting social policy, that would be
No,
acting on their...
if she could do it on a case-by-case basis, why can't she just do it as the rule?
Because that's the exact opposite of on a case-by-case basis, according to Swalback. I think that is literally the opposite of, a general rule is the opposite of case-by-case review. And an issue that I would like to bring to your attention is, the legislature does have a policy throughout the VTL.
But are you saying on a case-by-case basis, she can't rely on a rule? A rule that she is otherwise authorized to pass?
If you agree that the commissioner can make these value judgments and set social policy and resolve difficult social issues in a way that I believe the Boreale line of cases says that the commissioner cannot do, if you agree.
Yeah,
But if
well,
you
your
agree-
light is out, but I don't think that's what's going on, because you make the presumption that everyone's entitled to get a license, and they're not. It's already been revoked, but I know your time is done.
I don't believe, I feel that everyone is entitled to a driver's license. Thank you.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. The legislation to which my adversary referred, the 2006 legislation, is an apt illustration on why it is that DMV wasn't intending to overrule any kind of recidivist policy. In 2006, when the legislature enacted 1193 2B12, it simultaneously revisited 1193 2C1, which deals with relicensing of drunk drivers who've had their licenses revoked, and it made some adjustments, but it left DMV's discretion intact. This is the same as what's happened every time the legislature has looked at VTL
Counsel,
1193.
do you see 1193 2B12 as a floor or ceiling on the commissioner's discretion?
I see 2B12 as largely irrelevant to the issue of relicensing, Your Honor. 2B concerns the revocation of licenses, and 2C is the reissuance of licenses. So the legislature already has determined that there's a difference between revocation and reissuance. And this is consistent with its overall policy to get drunk drivers off the road by revoking their licenses, but then entrust DMV with the discretion to decide when and under what circumstances relicensing would occur. Now, DMV, in promulgating these rules, is doing nothing more than clarifying to the public how it is that it's going to exercise this discretion over a relatively narrow task that the legislature assigned it.
So what does it mean to have authorized on a case-by-case basis to refuse to restore a license?
What that means, Your Honor, is that as subject to the very narrow field that is subject to 2B12B, that DMV must consider them individually. Case by case doesn't equate to a presumption of waiver or reissuance. It simply means DMV should consider each and every application on its own merits, and it can deny as many as is necessary where the public interest in safe roads outweighs the individual interest in relicensing.
Going to do it pursuant to a rule that it's decided in advance?
Well, Your Honor, this isn't a rule that DMV has decided in advance. What DMV has done is articulated presumptive consequences for a certain subset of drivers that are applying for relicensing. And within these presumptions, DMV has said that if you fall within a certain category after it looks at your application, that you're going to presumptively be too dangerous to be fit to come back on the roads. However, DMV always retains the discretion to find that the individual interest does outweigh the public interest through the special circumstances exception.
Are there any limits on DMV's relicensing discretion?
Yes, Your Honor. And those limits can be found throughout the vehicle and traffic law. They come in the form of DMV's statutory mission, which is to protect the roads. And that's why I refer to this balancing between the public interest in road safety and the individual interest in relicensing. This interest doesn't allow for carve-outs. It doesn't allow for political, economic, or social considerations, such as what we saw in Boreali or Hispanic chambers. In fact, this balancing is the same kind of balancing.
What decision is not about protecting the roads? What could possibly, what, I mean, that seems extremely broad. Where's the line?
Well, I could give you an example, Your Honor. If DMV, for instance, determined by regulation that an individual with back child support, for instance, would be ineligible to receive relicensing, that would be something that's going outside its statutory mandate and would be suspect under Boreali.
Well, one of the Boreali factors that was cited in the dissent, the third Boreali factor, referred to no unsuccessful legislative attempts to resolve the issue that's before us now. In our analysis, we would rely on that factor. The dissent specifically talked about the failure of what was called Charlotte's Law, which would leave, which would basically have expanded permanent revocation by statute. And it was specifically cited in dissent. That failed, and yet, in essence, the regulation implements it. How would you respond to that?
I would say that Charlotte's Law, well, for one, Charlotte's Law was more narrow than what these regulations do. It only addressed one instance. So this is one bill that didn't make it past committee.
Well, I guess what I'm asking you to address, is that an unsuccessful legislative attempt to resolve the issue that's before us today that was resolved by the DMV?
No, Your Honor.
How so?
Because these bills don't signal, or this one bill does not signal the legislature's attempts to crowd the field. Now, at no point
I can't say that I understand that. They voted on it, it didn't pass, and now you basically did the same thing.
No, Your Honor. What DMV has done is articulate a series of presumptive consequences. Charlotte's Law would not have been presumptive, so this wouldn't have conflicted with Charlotte's Law in any event. And again, Charlotte's Law is extremely isolated. In the one instance that Charlotte's Law refers to, that doesn't mean that DMV would be constrained to approve relicensing in every other instance. It in fact illustrates that the legislature is, when it wants to, capable of curbing DMV's discretion here. I know my adversary referred to DMV's supposedly boundless discretion, but when the legislature has wanted to speak, it has. For instance, in 1193 2C3, it's articulated a very narrow circumstance where an individual would be ineligible for relicense permanently, and that is not on a presumptive basis. But that doesn't signal that DMV is constrained to approve relicensing on every other occasion, not least of which when DMV has allowed, or when the legislature has allowed DMV the discretion to decide applications for relicensing without qualification as to who, where, and under what circumstances. And there's a good reason for that, which is that the relicensing equation is inherently complex. When you're relicensing somebody, you're trying to evaluate whether they're fit to be back on the road. That can involve an infinite permutation of factors that is best left to DMV's expertise, as opposed to deciding the relatively simpler question of whether a particularly dangerous act on the road warrants revocation. So,
how about Vince's Law? You're familiar with that? The legislature rejected there a 21-year look-back, and then enacted a 15-year look-back, and now you've enacted, what, a 25-year look-back?
that's correct, Your Honor. But that said, that is simply one attempt that hasn't made it past committee, and this court has been very clear that legislative action is not probative of an intent to crowd the field on a particular
I think
subject
you're right.
matter.
I think you're right. It's an ambiguous path to go on because there's other factors that might come into play. That's certainly correct.
And I would implore this court that even if it had found that there were unsuccessful attempts in the legislature that signaled that
I guess
the
what it doesn't
legislature-
do is it doesn't answer how you are doing by regulation what the legislature failed to do by law.
Well, we're doing by regulation what the legislature has expressly permitted us to do by regulation, Your Honor. In 1193
What you're saying then is your discretion is so broad that if the legislature decides to make a law, is unable to do so, you still have the discretionary power to implement that policy through the use of your own regulations.
Yes, Your Honor, because and another thing that this court has decided expressly is that agencies are under no rigid marching orders. In this sense, this case is very similar to the rent stabilization case where the legislature...
Don't worry about those sounds,
Okay. So in cases like rent stabilization and General Electric, the legislature had created a concept and then the agency implemented it. Here, the legislature has created the opportunity for relicensing and expressly, by statute, said, DMV, this is your responsibility. DMV is discharging its responsibility. Now, I'm not going to say that if the legislature passes a law that conflicts with these regulations, that wouldn't serve to preempt the regulations, but it hasn't. And because it has already given DMV this authority that I'll note has been in existence since 1980, that DMV was perfectly within its rights
Also, in that
to amend
vein,
this.
these regulations have now been in effect, what, about 5 years?
Yes, Your Honor, and in those 5
Has the legislature
years...
taken a look at them and decided to do anything about them?
No, Your Honor, in these past 5 years, there hasn't even been a bill introduced that would purport to rein in DMV's authority, which signals that the legislature has been looking at what DMV has done and finds it consistent with its mission. I
Thank you,
see that my
counsel.
time's up. Thank you.
Thank you. Counsel?
Good afternoon, Jeffrey Lang on behalf of respondent. So I just first want to address the claim by petitioners in this case that the special exception 136.5D is a farce, and 2 points. One is that that claim isn't properly before the court. I mean, that's really a claim that this regulation, which allows DMV to consider exceptional circumstances, isn't properly being implemented by DMV. But in fact, the regulation is plainly there on its face, and what the petitioners have brought is a facial challenge to the regulations as opposed to an implementation challenge. And the second point is that there's just no merit to it. In fact, in the last 18 months, 19 special exceptions have been granted. So there's simply, and I believe there have been 11 that have been granted in the last year. So the claim that it's there in name only is simply false. Also, I'd like to address the issue of the what petitioners say is a conflict between the regulations and what I'll call the permanent revocation scheme in 1193 2B12. Now, this is very important. That permanent revocation scheme addresses a very, very narrow set of recidivists. And if the legislature wanted the treatment of those recidivists to somehow affect DMV's expressly granted unqualified broad relicensing authority under 1193 2C1, then it could easily have, it would have said so. It would have said so if this permanent revocation scheme were to have such a broad consequence. But even as to the persons who come within that scheme, which is none of the petitioners here, it doesn't even set any type of ceiling on what DMV can do, because all it says is that depending on exactly which provision you fit into, after a limited period of time, either 5 years or 8 years, DMV must waive the permanent revocation if certain statutory factors are met. Now, when DMV waives the permanent revocation, all that means is that DMV can, at that point, has to decide applies its relicensing regulations and still has to make a relicensing decision. And the permanent revocation provisions expressly say that nothing shall require DMV to relicense an applicant if DMV believes that it's contrary to public safety. Now, in the issue of deciding these on a case-by-case basis, all DMV has done here with the regulations is adopt a set of presumptive rules that allow for an applicant to put forward special circumstances. DMV does consider relicensing applications on a case-by-case basis. It has just applied essentially a set of proportional rules where persons who have 1 or 2 drunk driving convictions, they will normally just have to wait their statutory minimum period, and then they can be relicensed. Persons who are more serious, if you have 3 or 4, you have a waiting period, and if you have 3 or 4 in a serious driving offense, or 5, then you are presumptively revoked. That's a presumptive lifetime revocation.
That's what he's arguing, that you can't issue these presumptions. You're limited to the case-by-case analysis.
There's simply no support for an idea, for this notion that an agency isn't deciding applications on a case-by-case basis when it's using presumptive rules. Just to put this in context, DMV has received, since September 2012, when these regulations were enacted, has received approximately 13,000 applications. So these regulations just explain to the public how DMV is generally going to exercise its discretion when deciding applications on a case-by-case basis.
They serve to give guidance to the decision maker? Is that?
But precisely, they guide the person at DMV looking at these applications so that similarly situated persons are treated in a similar manner. They simply allow for consistent decision making.
But they can't ignore the presumption, right? They must apply. It's a mandatory presumption.
In the regulations, it's not it's a presumption, but again, and it is generally applied. But if persons have particular circumstances, such as a particular hardship that the lack of a license will cause, then that will cause them.
No, I understand your argument that the presumptions include exceptions. But the question is whether or not, other than based on an exception, can the decision maker ignore the presumption?
No.
No, so the presumption is mandatory, it always applies.
In that
To
sense,
the extent, I
yes.
just wanted to clarify sort of what your answer was to the chief judge was not, I didn't take it to suggest that they could ignore the presumption. The presumption is helpful, but the presumption is mandatory.
Yes, no, it's not that they ignore the presumption. They apply it. It's that an applicant always has the opportunity to put before DMV particular
You're
circumstances.
saying it's a rebuttable presumption.
Precisely.
Although it's you would agree it's a very high standard,
Yes, I would. Yeah.
and meant to be so.
Yes, exactly, because when you're dealing with such a large number of applicants, to ensure that DMV is applying its regulations consistently and meeting its statutory mission to promote public safety. A word about the look-back periods. There are certain statutory look-back periods, and Vince's law would have been a statutory look-back period. Now, those look-back periods are simply for different purposes. They apply to, for example, the elements of a criminal offense that determine whether or not you're aggravated DWI or regular DWI. They apply to set the minimum statutory waiting periods that determine a period during which a person is simply ineligible to apply for a new license. And those are generally shorter, and Vincent's law would have been something along those lines. It would have been a statutory look-back period. Now, nothing in the statutory look-back periods affects DMV's regulatory look-back period. That applies when DMV is applying its regulations to you. And, you know, again, if the legislature, and I should say the Fourth Department rejected this precise argument in the Dahlgren case where this court had denied leave. If the legislature wanted the shorter statutory look-back periods, just like if the legislature wanted the permanent revocation scheme in 1193-2B to cabin DMV's relicensing, plain relicensing authority under 1193-2C1, then it easily could have said so. And where the legislature did want to take away DMV's relicensing authority, which is in one narrow case where under 1193-2C3, you will never get your license back if you have two DWIs where there was physical injury in both cases. The legislature knew how to do so. It did so in that case, and if it wanted these statutory look-back periods to have that type of implication, it simply would have said so. I see my time is up unless there's any further questions.
Thank you, counsel. Counsel?
In the vehicle and traffic law, to my reading of it, there's an expressed legislative intent geared towards rehabilitation and geared towards conditional driving privileges. There are plenty of statutes that address those issues because I think the legislature realizes people do need to drive. They need to get to work. They need to get groceries. They need to go to the doctor. And to the extent that DMV does have discretion, if they were to say, you can only now drive conditionally for work purposes.
Yes, but the cases you're talking about are individuals who have had several incidences. This is not once. They've had several incidences. They've had the opportunity not to repeat these violations, and they are recidivists.
Absolutely, but my question...
And the policy in the VTL is that some recidivists do not get a license again.
But I guess my question would be, have any of them ever driven drunk while going to work, or driven drunk coming from work, or driven drunk to the doctor?
Well, you can make that argument to the legislature, but the policy is very clear. A series of incidents, if you're a recidivist, your license, you're not getting a license. It's been revoked, it's not going to be reinstated, you're not going to get another license.
The policy is clear, and I think the fact that it is a policy in and of itself makes it illegal, but the statute isn't clear that if you do this, you can't get a conditional license. The statute tends to favor conditional licenses. Now, I would like to close by saying that, current events have led us to see that public statements made in connection with administrative action can affect how it's reviewed. And if you just look at the press release that came out on the day of these regulations, it says, under current law, drivers who are convicted of multiple alcohol or drug-related driving offenses cannot permanently lose their licenses. Well, current law hasn't changed. So if they agree that the law doesn't allow this, and then, as was pointed out, Charlotte's Law didn't pass, I don't see how they can then say, we're just doing it anyway because these people deserve it. It would be so easy to pass.
If the exceptions weren't what you call a farce, do you lose?
Thank you, Your Honor. Subsequent to the briefing in this case, the appellate division decided, the third department decided Merkel versus New York State Department of Motor Vehicles. And Mr. Lang, I believe, was the attorney on the appeal. And the appeal dealt with an extenuating circumstances waiver application, and the appellate division unanimously found that DMV did not exercise any discretion whatsoever, misconstrued its authority under the regulation, and that the appeals board used an improper standard of review, and they remanded the case for a proper analysis. But I would say that the Merkel case...
That's an individual case, correct?
But if you look at Ms. Matsen's extenuating circumstances documents, which are on pages 179 and 180 of her record, and you compare that to the language that was referred to in Merkel, and I can tell you I have personally reviewed dozens and dozens of these denial letters on compelling circumstances claims. They're a form letter. The names change, the addresses change. It's a form. They're all just denied with a form letter. And
Counsel, I would like an answer to Judge Rivera's question.
can you please repeat the question? I thought I was.
I don't think you were.
So I must have misunderstood it.
The question is, if this were not a farce, if the waiver were not a farce, would you lose?
I guess it depends on how much of not a farce they are or were. Because if 19 people in 4.5 years are getting waivers and thousands and thousands
You're
of
disagreeing
people...
with the numerical outcome. The question is whether or not it provides a genuine opportunity for the individual.
In the record...
And is that a farce?
DMV counsel had submitted an affidavit, which I had enclosed as an addendum in my reply, saying that needing to get back and forth to work is not a hardship, and completing rehabilitation is also something everybody does, and that those, being rehabilitated and needing to get to work are not sufficient to get a waiver, then I would say that it's a farce in the sense that what could be compelling under that circumstance? Everybody, I'm not saying that a waiver should be given.
You are answering that it is a farce. You are not answering what if it weren't, would you lose?
If it weren't, we are still dealing with administrative policymaking regardless. And just because they've left a safety valve doesn't change what they've done. And they have legislated under the guise of administrative rulemaking. And just because they have a waiver provision, even if it was legitimate, doesn't change that the general policy is policymaking. Thank you.
Thank you, counsel.